this morning, I'm going to be meeting with Thomas Jeter of Nosal and Jeter, who I've known for quite a few years. He's in my B&I group together, and I'm excited to talk to him because I've got some questions I want to ask him about with trusts, when people move into the area, businesses as well, just like a small business owner myself, just having an LLC. There's different things you're supposed to do at the end of every year that I know I always forget to do, so I want to ask him about that. And he also helps people that are speeders, and there's an important piece to that. But really, the wills and trust is the biggest piece. So I hope you enjoy it. He's going to be great. So today I'm here with Thomas Jeter, and we're going to talk about different aspects of his law firm and what they do, and just kind of go over some key points so that we can help our listeners today. So Thomas, I really wanted to touch on something that you talked about at one of our B&I things, and that was when, especially like myself as a realtor, we have so many people moving in from out of state. And I know you helped me with my mother. She had a trust, and pretty much her assets, a lot of it had been liquidated, but we were concerned about power of attorney as she was aging and different things like that, and you helped me. What are some of the key things that you think somebody needs to know when they first move into town, and let's say they just have a will?
Well, you're getting your documents updated, or at least you're taking a look at by a local lawyer in that state. It's always a good idea whenever someone first relocates to a new state. Mm-hmm. Every state has state-specific laws that govern wills, power of attorney, healthcare power of attorney, trust. And you just want to make sure your old documents at least comply with the new laws, and if not, update any of the more state-specific forms, especially the healthcare power of attorney, living will, advanced healthcare directive. It's always a good idea to make sure you have the local forms for that, so that there's no interruption if ever you needed access to medical information, or if you need someone to act on your behalf for making any type of healthcare decision, that you've got the forms that doctors are familiar with and are used to using. And it'll also for wills, a will from another state, generally should be good, in North Carolina, but practically speaking, there's plenty of situations in which it's very difficult to probate out of state will because of various formalities that aren't the same in North Carolina.
Because you have to go to the county where they died. Is that what it is? And
the county of Statesboro is the county where someone lived whenever they passed away.
Gotcha.
But if the will is done in another state, another county, it may be difficult to track down witnesses. Maybe that state didn't require a self-proving affidavit or some other verification documents that are necessary in order to get the will admitted to probate in North Carolina.
It seems so hard for anyone to do their will in the first place, to actually get them to do, you know what I mean? There's a lot of people who just procrastinate.
People don't procrastinate that. It's something people always often put off. If you're moving to a new state, it's always a good time to, if you're one who's going to procrastinate that, always a good time to maybe go ahead and take that step to have that done.
Yeah. I'm thinking that as realtors, maybe it could be part of like our process. Here's a list of quality people I really highly recommend that you contact, and definitely be thinking about your wills, your trust, that you need to have it reviewed now that you moved into the state. So that could be more of a good point for realtors to be taking action on.
Especially in the sense that if someone's buying a house here, then they own real property in North Carolina.
Yes.
That's going to pass under North Carolina law, and your current will or trust may not be set up to properly take that into consideration.
Good point.
And if you have a trust set up, maybe you want to go ahead and have that property put into your trust whenever you buy it.
Oh, of course, yes, because
so that's
change
another
title over to that.
thing as well, to go ahead and get the title changed to that, to your trust. The good thing about trust as well is that a trust is easier to move a trust from state to state, and that you could have a trust under a different state's law and be administered in whatever state you live in. But you still want to make sure that trust is properly set up to hold any of the real estate in the state that you own.
I know what I wanted to ask you, like a durable power of attorney. People get confused between a power of attorney and a durable power of attorney, a healthcare power of attorney. Are they all the same thing? Is a durable power of attorney, what is it durable for, and who does it apply to?
Durable power of attorney is generally referred to as part of a financial power of attorney. And durable is in the sense that it survives any future incapacity or incompetency by the the person who sets up the power of attorney.
While that person's alive.
While that person's alive, once someone's deceased, the power of attorney has no legal effect anymore.
Okay.
That's when the will would kick in at that point.
Okay, good. And then a healthcare power of attorney, is that only for medical scenarios? So like I have a healthcare power of attorney for my mother, so her doctor has a copy of it, the hospital has a copy
A
of it.
healthcare power of attorney is a completely separate document that is used for making medical decisions, different from a financial or durable power of attorney.
Okay.
And both those documents are important to have. One's for generally used for financial decisions, one for medical decisions.
Right.
Could be the same person named as your agent in both of those documents,
right?
or it
You
could
have
be different people. If you've got one family member that you trust with financial matters and another one that you think would be better at making medical decisions, you can certainly have two different people in those roles.
Sure. And what about, so we've got durable, healthcare, and then a power of attorney. There's no
There's certain other limited power attorneys, as you've probably seen, for a limited power attorney to sell real estate or something
gotcha.
like that.
Yes.
But general and durable, general means it can be used for multiple different purposes. Again, the power attorney will spell out what those would be.
Gotcha.
And then durable would survive any future incompetency.
Right. Like I have a durable power of attorney for my mother on her financial affairs. So I can contact the bank, I can move money around, I can sell property, I have all that power. So that helps me with that. I'm grateful to have the healthcare power of attorney. And I think a lot of people don't understand the importance of that healthcare power of attorney. Like people whose children, let's say, are now 21, but they may still be off at college or something, and something happens to them. Do the parents have rights for those children to make medical decisions, or do they need a healthcare power of attorney?
Well, anyone who's over 18 is good to have a durable and a healthcare power of attorney, especially if someone who's unmarried and doesn't have a spouse who would be the natural person the doctor would go to.
Right.
If someone's over 18 and is an adult, the parents don't have the right to access the medical information that they would if the child was a minor still.
So it's 18, it's not 21. 18.
It would be 18, correct.
Wow. So all those kids that go off to college, if they don't have a durable, even if they're on their own health insurance like that, like if the parent had the 18-year-old and they're off to college on their health insurance, but they got injured, and let's say they were in a car accident and a coma and some medical decisions had to be made, the parent would really need a healthcare power of attorney to be able to protect that child?
Yeah, I mean, that'd be something that's very important to have that.
That's a
have
big
that
deal.
document in place. It is, especially if the person is, the child is, when you say child, it is their child, but they're over 18, they're an adult now.
I'll bet you a ton of people don't know that. I'll bet you a ton of people don't know that. That's a really valuable thing to know.
Yeah,
So,
if people are young, think that nothing's going to happen to them, but I mean, that's the age when they're
Crazy.
might not be making the best decisions in
Yeah.
college, and
yeah.
you could get in an accident injury situation
Yeah.
where they need someone to act on their behalf.
Wow.
Because it's not the parent's decision who is the agent. Sometimes that's a issue that comes up, is that the parents bring their child to us to get a power of attorney set up, and
Yeah.
the parents are surprised when we kick them out of the office and meet with the child individually, because it's their decision. Who do they want to be their power of attorney?
It could be the current girlfriend
It
or
could
boyfriend.
be. It's really, I mean, they're an adult. It's
Best friend.
it's their
right?
decision. 9 times out of 10, they do pick their parents do that as, until they're married. Then most people do pick their spouse.
Sure, sure.
But if they're in college or younger in their 20s, a lot of people would still have their parents. But it could be a friend, could be a girlfriend.
Right.
But it's that person who sets up the power of attorney, who has the authority to decide who they want to do it at that point.
Right. So that's really interesting, because I was thinking, now if you're married, that's a non-issue, right? Because your spouse is automatically allowed to make those decisions?
Again, it's still a good idea to have that power of
Really?
attorney in place so that there's no conflict issue. Most of the time, the doctors will defer to the spouse, at least from what I've seen in our experience, but still to have that legal authority to act on someone's behalf.
Right.
Having that power of attorney, the healthcare power of attorney is very important for that.
Now, within the healthcare power of attorney, is that where you've got the DNR scenarios? Is that part of it?
A DNR is a separate document that would be set up by the hospital if you were under.
Like a living will or something?
A living will is a advanced directive that would go along with a healthcare power of attorney.
Okay.
We generally kind of do those as a package deal together, but the living will only relates to certain end-of-life situations and whether you want to be artificially kept alive on life-supporting measures as opposed to the willing will just is a general statement, and you can qualify what your wishes are in that document that you don't want to be kept on
Right.
life support if you're in a vegetative state or in a end of life situation.
I know you did that as a package thing for me with my mother, and I just had to bring it to the hospital and validate all of that with them. So I was glad we had sat down as soon as she met here. And you know, I wouldn't have thought of it if something hadn't triggered it and something that you told us at our BNI meeting. So that was helpful to me. And I think these little videos that we're going to be creating will be helpful to other people to kind of trigger their thoughts. You know, we need to get this done and addressed right away, because you just never know. Look at the flu that's going on
Yeah.
these days. This is a big deal, and people are ending up in really life-challenging situations just with the flu, but all kinds of stuff, car accidents, you name it. You mentioned something to me like when you travel, you typically see it a lot. Like when you traveled, you got your stuff in order, or different other people travel, they get their stuff in order. I think it triggers.
Well, people definitely procrastinate, and it's something
Yeah.
it's easy to procrastinate because
Yeah.
you know, you don't think anything's going to happen to you,
Right.
especially the younger you are.
Yeah.
The less you think that you really need to worry about end of life or any planning for incapacity,
Right.
anything like that. But yeah, when you're going on a trip, it's always, you know, it always pops people's minds, and certainly myself as well, that, you know, I need to make sure I've got everything in order in case something did happen when we were gone, especially if me and my wife were traveling together.
Sure.
You know, make sure all of our trust for our daughter, everything was set up in an order, and
Sure.
you know, power of attorneys, healthcare power of attorney, all those documents in place.
What do you feel as far as re-looking at it? Is it good, one and done? If I live in North Carolina, I never need to look at it again. I set it up. Am I done, or should I review it every so often?
I generally feel it's good to review every 3 to 5 years in general. It doesn't necessarily mean you have to update it,
Right.
but just to pull it out of the safe, you know, dust it off and read it, make sure it still meets whatever your goals and objectives are, and make sure people you've named in there haven't passed away or are still or still who you would want to serve in certain roles, such as your executor of your will or your agent for your power of attorney.
So it's kind of like I'm reviewing it first. If everybody on there is still around and yeah, that meets my objective, should I have you review it though to kind of say rules have changed out here? We gotta, or no?
Well, the first time to review it yourself first to make sure that number one, if there's something you want to change in it, then that's an obvious reason to
Right.
get an attorney to review it. The other thing, every so often, 3 to 5 years, you want to make sure the laws haven't changed
Right.
to a point to where it's going to affect anything in your
Sure.
estate planning documents.
I know what I wanted to ask you about. So wills and trusts. So wills guarantee probate. Where trusts and they're limited as far as their ability to define how you can do your assets, and so you have to go through probate. And but a trust is a lot more flexible. You can be very defined of how you want things to go. Who would you say is your normal person or a typical person that would want to have a trust?
Well, we're doing a lot more trust plans for people now. Again, for one of the main benefits of that is avoiding probate, avoiding
Right.
having your assets go through probate, and the time delays with that,
Time delays.
the additional cost and attorney's fees, administrative costs,
Right.
court costs, and the public nature of that. Everything through your will that goes through probate is all inventoried and listed in the public record, and anyone
Right.
can go look that up and know who's receiving what from you. And then trust, especially with trust, it's a private document that it's administered by your successor trustee. I mean, generally with a living trust, you're not giving up control over it during your lifetime. You're your own trustee. And then you're naming a successor to essentially act as your executor to carry out the terms of your trust.
Right.
It could be just divide everything up amongst beneficiaries and pay it outright, or it could be held for a period of years or a period of time, depending on the age of the beneficiaries or your specific terms you want to put in there.
Now, in my mother's situation, she was in a second marriage. She had lots of different properties that she owned herself, and her husband had properties that he owned. He had heirs he wanted to go to. So I suggested to them years ago that they both get their own separate trusts, and that they keep their assets separate so that they could go to their heirs how they wanted. So they ended up doing that. And I think that there's so many second marriages that go on today that people need to think about that, because a will can really muddy it up, even right down to the minute someone died. Like if a couple died in a car crash, like who died first and how did the assets go in that perspective, right?
Right. I mean, second marriages always present challenges in estate planning. Those are ones that should be handled with even more importance because
Yeah.
again, most people may say, I want everything to go to my spouse to provide for them for the rest of their life, but
Right.
then ultimately I want whatever's left to go to my children, maybe from a prior marriage,
Right.
in which if you just left everything to that spouse in a will, then there's nothing, then they can deal with it whatever they want with it at that point, and it will likely go to their children at that point. So that's just one of those things that just, again, some people have assets titled jointly, some people have more things separate. Each
Yes.
family's different in that situation, and we generally handle those based upon how that couple wants to do it. But just, second marriages do present a challenge for estate planning, but it really just highlights the importance of doing it and having good documents set up to
Right.
make sure that what your wishes really are enforced upon your
Yes.
death.
Because I've just seen, I've just been associated, because in my previous career as a estate planning, we just saw the importance of how things were titled, and you saw the complications in deaths or scenarios like that of how family fights broke out like crazy, and which I know was not the intent of the people who passed, because they had a vision of it going a certain way, but they legally didn't set it up properly, and the consequences of it were so traumatic to the families and just really just blew up relationships like crazy.
Yeah, well, that's a good point, Kathy, is that how things are titled does matter a lot in estate planning, and that's one of the areas that we try to go over with people in detail, is to make sure that not only are your documents drafted, but that your trust has been funded, or the documents are funded to where they work together,
Right.
as far as a will and a trust together, or different assets titled together. Again, if you had a will that said you want everything to go to your children from a prior marriage, but you had a house owned jointly with your wife, and a joint with right survivorship accounts, and had your wife named as beneficiary and life insurance,
Yes.
and ultimately nothing went through that will, then clearly there's your children may have they may have a misconception that they were going to inherit all
Yes.
these assets of yours, but ultimately because of the way the different assets were set up as far as the title of them was concerned, they went to different people other than what your will says.
And even if those people were, let's say the spouse got all these things, but she wanted to do what her husband wanted her to do and give him to that, she creates a tax liability for herself, because now she's gifting things to them, right? Because she inherited it. So let's say she wanted to sell these different houses and gift the money to those heirs as if the dad wanted it. But because she owns it now, there's a tax consequence to it, right?
Well, again, that's true. It's complicated, and it's even more complicated because I hardly ever see that situation where someone wants to give it to somebody else because that's what they thought the person wanted. Again, the person named that spouse as the beneficiary on that account. So that would
really
generally that would be the evidence that they wanted to give to them.
Yes.
It's just one of those things that changing the person's wishes. I mean, there are situations where it can be done, but
Yes.
but most of the time, those inadvertent things
Right.
really can have serious consequences and create a lot of family animosity.
So
There's a greater situation that if someone's legally entitled to something, that they're going to want to keep it.
Yes. Yeah. I figured pretty rare would be someone who says, yeah, I'll still give it to you. I agree. What I remember one time was a friend of mine, his mother, when her husband died, she put her 3 children on title with her with the house. This is a common thing that people will do. So she put her 3 children on, but it was right of survival, not right, I forget how which one's which. But what happened was, so now it's the mother with her 2 sons. So the one son died. Well, his piece, his third, because it was now the 3 of them, the mother, the 2 sons, it went to the wife because he died. So it went to a wife.
Right.
And then she ends up dying, and it now goes to her 2 kids. So her 2 kids, the first son and the mother, originally are now the owners of this property. But the mother never understood this when she changed and put these people on. What's that title called? Is that testament?
Probably tenants in common
Tenants in
ownership
common, that's
is
what
how
it
it was. That's something to think about is that when you're doing your estate planning, people don't want to ever think about this, but you have to also consider what if what if a child or children predecease you, then where's the
Yes.
property going to go?
Well, and
And
she wanted to sell the house. And I said, we have to, first of all, none of them had gone through probate. One was a trust and one was probate. So of the husband and wife that died. So I said, those estates have to be cleared up before you can even get the title to be able to have clear title to even sell your property, even though you think you own it. And so it was a nightmare. So I think in every situation, when someone is going to change the title on their property, they should always seek the advice of an attorney who understands all these principles, don't you think?
Well, yeah, absolutely. I mean,
Yeah.
that's a deed is certainly a legal document that you want to be done correctly. I've seen a lot of people try to do their own quitclaim deeds, and those
That's
ultimately
what they did.
end up having a lot of title issue problems
Yes.
whenever they go to sell the property or something wasn't done right.
Yes.
And they can't get insurable title for it.
This is where it's important if you are working with a financial planner and an attorney, you have to look at the whole picture, and I think people don't take this serious enough of what, you're owning different assets. These are a big deal, and how you want things to go with your family. You have to pay attention to, dealing with it as a real important thing that's a necessity to address, and not something to just be put off because it's an easy thing to just put off. I think these are such important details to be attending to, don't you think?
Yeah, absolutely. And
Yeah.
joint ownership of real estate, can create a lot of headaches for people.
Yeah.
And they certainly need to understand how it's set up and know what
Right.
different decisions they make or how that could impact them in the future or impact their families in the future as well.
So when you do a trust and you set it up, there's probably like a checklist where you've kind of reviewed their different assets and have said, this, we should probably move over into the trust. Don't put this in. Like, I've seen cars not be something to put into a trust. Would you agree with that?
Yeah, we hardly ever recommend doing
Right, because you can get into a car accident and have a lawsuit, and then they can sue. They have access to the trust. Then.
Correct. Here.
Right. So, but typically your checking accounts, your homes, the things that you've got, and also people with certain size estates, I know that they do split trusts, right? There's different types that you can do.
There's certainly all different types of trusts.
Yeah.
Probably more than we can go into
Sure.
today, but the most common type of trust is a living trust or a trust that you set up now where you're the trustee of your own trust, revocable, correct?
Living trust.
In which that you can change revocable since you can change it at any time during your lifetime, make amendments to it, add property to it, take property out of it. You're not giving up any control.
Right. I think that's the missing piece that so many people think. And also I think everyone thinks it's only for the wealthy. It's not. Because people aren't adding it even in their life insurance amounts of what their total value of their estate is, I think. Where people need to look at it, the whole picture, wouldn't you say?
Well, certainly, especially people with young children as well.
Yes.
You got life insurance that might pay into your estate.
Right.
You need to make sure you've provided for a plan, which would be part of the trust as far as how's that money going to be administered and spent for that child to make sure that they have things that they need
Right.
growing up. Be used for their health, education, maintenance, and support. It's kind of the
Right.
general ascertainable standard for that. But then also, what age can they get the balance of their share outright?
Right.
Who's going to be in charge of taking care of that money? Maybe you don't want it to be your ex-spouse in charge of the money. If you want
Right.
to appoint someone that's your opportunity to appoint someone that you want
Right.
to manage that money for for your children, and that's an invaluable thing that you can put into a trust and have it extend beyond their 18th birthday. It could be till
Right.
25, 30, 40, whatever age you choose.
Because you can design it.
Right.
Right. I know I did that for my kids when I was little. My trust was set up because I was a single parent. I did not want my ex-husband to be responsible for the money part of it, so I assigned someone else as that person. I also wanted to put instructions in there that I wanted my kids to go to private schools. So I wanted the money to go in to be able to fund that. And so my life insurance policy was geared toward funding my trust.
Right.
And then I also wanted it to hopefully carry on to be able to go for college. But if they didn't want college, it even had terms in there as is as significant as where they could have startup money for a company if they wanted to start it. So there were options, but that's the beauty of a trust, right? You can define it.
Yeah, I mean, it's your document to tell what you want to happen. You can
Yeah.
you can get as specific as you want to with it. I mean, sometimes I caution going not to get too specific because you don't want to end up. Then there's people who end up coming back and changing it all the time. You need to be at least general enough terms that the trustee you can act and do what
Sure.
and deal with changes in circumstances.
That makes sense. That makes sense a lot.
But at the same time, you can certainly put your wishes in there as far as schooling goes and things like that. You need to really because if you're not here anymore, you want to make sure that your money's used for your kids to raise them as if you were here still.
Right.